Good afternoon to all my colleagues here in the property group. I hope you are all enjoying the lunchtime refreshments at our disposal here, thanks to the catering staff. Our legal services at this firm are often required on behalf of lessors in dealing with matters connected to retail shop leases. Therefore, I have prepared this short presentation to further discuss the advantages and disadvantages to the legal position of lessors in relation to the new legislative reforms. As you would all be aware, the Retail Shop Leases Amendment Act in 2016 introduced reforms to the old Act, which is the Retail Shop Leases 1994. The changes to the Act commenced on the 25th of November 2016. The coverage of the Act has changed significantly, including the rule for area space. If we consider the provision of Section 5A, 2A, the amendments to the legislation allow for retail shop leases with a floor area of more than 1,000 metres squared not to be subject to the rigorous provisions in the RSLA. This rule works as an advantage in a way, as it does allow more of the lease terms to be negotiated. However, a slight disadvantage in these terms are no longer unchallengeable or undisputable terms, which can be bad for both parties depending on provisions in the lease. Lessors also now have the advantage of being able to lease a premises to a tenant, which is classed as an employee or an agent of the lessor, for the purpose of conducting a retail business without having to abide by the provisions in the Act. If we now move on to look at compensation and the important changes to those provisions, a very significant change which really stands out is that of Section 43AB, in which a landlord is now not liable to pay compensation to a tenant for taking reasonable action in response to an emergency. A great example of this is the closure of a shopping centre due to flooding. We all remember in 2013, Bundaberg, Queensland, saw some quite remarkable flooding, which saw the local shopping centre Hinkler Place closed for a number of months. If such a natural disaster were to reoccur, since these amendments to the legislation, the lessor would save a huge sum of money without having to pay compensation to a number of tenants in the centre whilst the premises is closed for business. In regards to pre-lease disclosure requirements, Part 5A of the Act has undergone changes. Disclosures still need to be provided before the lease is entered into. However, there is now a 7-day disclosure waiver period that can be exercised at the discretion of non-major tenants and assignees, allowing for the landlord to have more time to prepare the disclosure statement prior to the lease. Section 38 of the Act provides some fundamental changes to the dealing with the landlord's outgoings for retail shop leases in a shopping centre complex. Estimates of outgoings considered by a landlord must provide a detailed analysis of the fees to be funded by the tenant in regards to the admin and management of the centre. So that's fees going towards the admin and management of the centre. This will provide a considerable amount of work to the landlord's planning and estimation of outgoings, which must be accurately assigned to the tenant. The last change I will mention is in relation to opening hours of a retail business. Section 53 has been updated and essentially replaced. The provisions now indicate that a term in a lease agreement that permits rather than requires a shop to open outside core trading hours is invalid. This works to the lessor's advantage, as there is now more certainty available in this area of lease terms, and the lessor can have a better understanding of when the retail business will be open for trading in the premises. This presentation has outlined the key changes in the Act, with focus on both advantages and disadvantages which affect future and present clients of our firm. I hope you have found this analysis of information enlightening and effective for helping assist relatable clients. A breakdown of these changes should be useful for advising lessor clients of their rights, duties and obligations to lessees and other parties. Thank you.